Yeah, this is Paul. Yeah. I was going through this response from the state of Washington. Yes. About the domestic violence protection order. Yes. And it says here, state's response to defendant's motion to dismiss. To deny the defendant is charged of violating protection pursuant of RCW 2650. In order to convict the defendant of this crime, the state must prove the following elements beyond a reasonable doubt: that on or about December 31st, 2015, there existed a protection order issued for the protection of Heidi Budnek applicable to the defendant. It was issued for her, but there was no signature of the petitioner, so did the state decide that they were going to protect Heidi Budnek without Heidi Budnek wanting the protection of the state? You would think if a petitioner wanted a protection, or a petitioner would have signed it. Now, it could have been that Heidi Budnek was no longer fearful of Paul Budnek, but it looks like the state of Washington decided that they were going to decide that she needed to be protected whether she wanted that or not. The defendant knew of the existence of the order. I was served in a public library, and I'm sure that those library patrons, when I finally get the domestic violence in the United States enforced, that would be that new form of government that decides that they're going to make every decision for the citizens, whether they want those decisions or not. Now, I found guarantee one place in the Constitution. There might be other guarantees that I'm not aware of. But I did know that it existed because I was served in a public library without actual notice or opportunity to be heard before it was issued. The defendant, that on or about December 31st, the defendant knowingly violated a provision of the order restraining the defendant from having any contact with Ms. Budnek. As I had documented, I was not in Squim on December 31st. I was on the bus, and the surveillance camera should prove that. And I sent an email from the Port Angeles Library 2 minutes before the alleged violation that took place on December 31st. So the defendant did not knowingly violate the provisions of it because I was not in Squim. That the defendant's act occurred in Clallam County, Washington. As the defendant, I did not have an act that had occurred in Clallam County because I was not in Squim on that day. The order for protection was entered on July 31st, 2015 in Clallam County Superior Court case number 112006711. It remains in effect until July 31st of 2025. It protects Heidi Budnek and her children and restrains Paul Budnek. Mr. Budnek was personally served the order for protection on August 15th of 2015. The protection order protects Heidi Budnek and her children without any jurisdiction, and it's quite possible I haven't spoke to Mrs. Budnek, but we're still married, that she didn't want the order for protection, but the state of Washington decided they were going to commit the act of domestic violence against the rights of the citizens. There is no need for protection for either Mrs. Budnek or her children because there was never any domestic violence, there was never any child abuse, and there was never any spousal abuse. Defense counsel requests that the state prove the defendant received actual notice of the petitioner's request for a permanent order. Now, did the petitioner request that? Because I don't see her signature on the protection order. So how do I know she requested it? I'm going to call you back.